Good morning, friends. Adab, Sat Sri Akal, Namaskar. Today I will be discussing a case of Jabalpur, Mr. Indu Rakhia. We became very close to each other way back in 2010-11. I remember when we were in Jabalpur, what a treatment we got by one of their board member or somebody called Choksi or something like that. It was Mr. Deepak Agarwal, late, who managed to consolidate the situation, and finally Mr. Bajang Prasad's family owner, Mr. Sanyal, took us to their house, Sangal. This case is very peculiar. Mr. Indu Rakhia was a very learned man on cantonment laws and by itself on the judiciary itself. So he knew how to take things, So this bungalow, number 4, survey number 94, 3 Bridge Road. He actually purchased this bungalow, I think, way back in 68. And this bungalow was on hire with the army by the predecessor. So, what was the status when he bought it? That is the question. The Colonel Venugonalan, who was actually occupying this bungalow, could be on behalf of the army or of the MES or of the LMA, actually handed over this bungalow on 1912-1968 to the new incumbent, that is Mr. Indu Rakhia. Now the army and the department actually starts putting up the thought that this bungalow was illegally taken over by the owner, and he started residing into it. A situation rose to such an extent that the army, with some 150 men, actually barged into the bungalow, broke open the locks, gates, assaulted the servants, and obstructed to the enjoyment of the property owner. So a case was filed. Now, because Mr. Indu Rakhia was confident and was very strong, he filed multiple cases. Most of the cases were just related to injunction and possession. The issue of ownership was never picked up. So his entire case used to run on the flux of time. So suits were filed in 74, 68, 1980. There was a judgment in 1983 in Appeal 34A, 1982. Then there was a civil suit filed 48A, 1982 in Civil Judge Jabalpur. All these cases were getting culminated. Even a criminal complaint was filed under the criminal procedure against the army. Finally, it didn't see its fate because the court quashed that complaint in the thought that nothing like trespassing or anything was being done by the army. But the entire thing was Mr. Indu Rakhia remained in possession, whether his servants were there. He showed his possession from that date of 1912-1968. And from there he moved his case to the courts. Now this property was in a dilapidated situation either. So maybe the main building was not in a position, because honestly speaking, I had not seen the property when we visited Jabalpur. Yes, Mr. Indu Rakhia came and met us at Mr. Sangal's house, but he didn't want us to see his property, neither did he share these papers. So I laid my hands on these papers through a bungalow owner in Jabalpur itself only. But later when I told Mr. Indu Rakhia that these papers are with me and I have gone through all your judgments and These were judgments on injunctions and on possessions. So nowhere the issue of ownership actually woke up. Yes, you claimed yourself to be an owner, but you never filed a suit for declaration. So then he understood that vice versa, even I could read through the judgments which went up till Supreme Court. I will just read them. So there was this lease agreement of 1953 between Raza Bali Suleimanji and the Union of India for 5 years. Now this Suleimanji was actually the one who sold this. But when Mr. Indu Rakhia purchased this property, he actually was in possession of the property. Maybe some outhouses were in the possession of Mr. Suleimanji or whatever. I'm not going into those nitty-gritties. Since the army, in the court, as well as the DOs and everybody accepted that yes, Mr. Indu Rakhia was in possession and this colonel had given the possession to so-and-so. Now, what were the findings in the civil suit of 76A 1974? It's very important. The suit was not getting finalized and there was another suit filed against the brigadier by the respondent Induji. So what I'm trying to say, there is so much of multiple litigation happening this side, that side, individually on DO's name, individually on the brigadier's name. So nothing. But the most vital point in this entire case was that he could show a sale deed of 10th March 1903 to the court, which clear title, absolutely read for ownership. Nowhere the word grant or anything like this was used. So this sale deed actually was his savior. His possession, whether it is because his sale deed was not speaking on that terms. So this finally went up and this clear title was being proved. And Mr. Indu Rakhia Mr. Suleiman's lease agreement was somewhere. And pleadings were that under the House Accommodation Act, Section 10C, which I speak of, he could not have been deprived of his possession when he was in possession. Now this is very important in this section what is written. If the owner is in possession, so he pleaded with this because of his knowledge and his ability. So finally, when the department, Union of India, lost in the lower court as well as in the session, they filed a second appeal in the higher court, number 418 of 1983. The whole case was being discussed on this section 241 of Cantonment Act 1924, CLA rules 48, 1937. These are all related to inspection, barging into the bungalow. So the court really, was not very keen on doing anything like this. They finally dismissed that Union of India's plea. Union of India even came to Supreme Court and filed an SLP 11304 of 1984. The fate of the SLP was also similar and it got dismissed. Now, after reading the whole case, I fished out these 2-3 points. 1903 House Accommodation Act, the sections which he used was of Cantonment Act, whether the army under CLA rules or the MEO, whether they could barge into the bungalow and all. So he was fighting his entire case on these facts. And during this period when the possession was there even was a case filed under section 185 of the Cantonment Act for unauthorized construction. But since there was so much of multiple litigation, I have that one court order of his lower court of this unauthorized construction. But nothing further. What is the fate of the case? Because I remember when I was talking to him in 2014, he used to ask for a lot of documents from me regarding House Accommodation Act and then various rules and regulations which we used to discuss for hours together. But, I don't know whether Jabalpur people feel that this is a case of ownership and he's won his ownership of the old Grand Bungalow. Yes, 1903 sale deed has been exhibited, has been proved in this case. But the issue of ownership never came up into this case. So, we have to understand, till we do not have our records, till we do not have the ability to fight the department through criminal complaints, to different cases under CPC, different suits, whether injunction, possession, suit for declaration. But, somewhere when we move in for suit for declaration, the entire onus of ownership and proving comes to us. So we need to dig into our records. Anybody in Jabalpur can get in touch, lay hands on the evidences laid by Indu Rakhia ji. This is all public documents. Nobody should be offended of these documents available to everybody. We need to open up, I'm saying. We all bungalow owners, whether in Rawalpindi, I know many people from Peshawar call me up, whether Sikandrabad, Barakpur, we need to open up. Because these pleadings, these facts which have already been dealt, which have been countered by the department, we need to know they have a jumble of judgments together. So their legal cells are very much aware of every case. Out of these 90,000 or let's say less grants available in the whole of India along with Pakistan, Bangladesh, Burma and everywhere. So we need to dig into this. Because once we dig into it, I can more precisely say that yes, we were old grants. The Britishers never converted us into new grants. Why they didn't do it? It's an headache to be known from there. Why does the GLR doesn't call us a grant itself? It should call us why does it call us an old grant? So that's it. So guys, just wake up and get in touch. Thank you. Good day.